I am Bill Rochelle, the columnist and editor-at-large for American Bankruptcy Institute. Today on Rochelle's Daily Wire Video Edition, we're talking about venue. In particular, I'm going to mention two cases demonstrating how it is difficult to move a bankruptcy case from wherever the case was originally filed. First, we go to Kansas. Before its bankruptcy filing, Yellow Transit, the big less than truckload carrier, had sued its union in federal district court in Kansas, asking the district judge to enjoin the union from striking. The district judge said that she had no authority to enjoin a strike, and you know what happened. There was a strike, and Yellow ended up in a Chapter 11 case in Delaware, where it is liquidating its assets. Once in bankruptcy, the Yellow debtor went to the district court in Kansas and said, listen here, we are now in bankruptcy, and for a lot of reasons, we would like for you to transfer that lawsuit to the bankruptcy court in Delaware. And, oh, by the way, once in bankruptcy, we believe that our action for damages is one of the largest assets of this bankrupt estate. In rather short order, the district judge in Kansas, after a thorough analysis, however, said, no, I can decide this case just as well and perhaps better than the bankruptcy judge in Delaware, and so she denied the motion to transfer venue. In the coming week, I'm going to report a venue decision by a bankruptcy judge in Delaware under rather interesting circumstances. Before bankruptcy, the principal lender had exercised its lien rights and had taken over all of the stock, in effect became the controlling shareholder of this debtor. Also before bankruptcy, and not long before bankruptcy, the secured lender created a holding company that it owned and incorporated that holding company in Delaware, and it was that holding company that received ownership of this soon-to-be debtor. Well, not long after the holding company was incorporated in Delaware, the principal creditor put that holding company into Chapter 11 in Delaware. Now, the debtor was not a Delaware corporation. Rather, its head office was in Arizona, where it was incorporated. But the debtor, by virtue of the fact that it was an affiliate of the holding company, was entitled to file its bankruptcy also in Delaware, making the venue theoretically permissible. The creditors committee and the U.S. trustee moved to transfer venue to Arizona, saying that the venue in Delaware was basically manufactured on the eve of bankruptcy. And they pointed to two cases under what they thought were similar circumstances where venue was transferred. In both of those cases, however, it was the debtors who reincorporated themselves in the districts where they wanted to file bankruptcy. And in those two cases, one in North Carolina and one in New York, the bankruptcy judges said, no, you cannot manufacture venue. But this bankruptcy judge in Delaware said, no, those cases are different because here it was the principal creditor who, in substance, manufactured venue. And the bankruptcy judge in Delaware said, no, I'm not going to transfer that case to Arizona. As I said, I am Bill Rochelle, the editor-at-large for American Bankruptcy Institute. I shall return same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe, and a good day.